I may be ethically obligated to make a complaint to the bar. I will review the Nevada Code of Judicial Conduct. 20 TRT, Toll versus Gilman. Mr. Toll is representing Attorney Mr. Busby. Mr. Flangas is not present. Mr. Busby, you go next.
Thank you.
Mr. Busby.
Good morning, Your Honor. This is the time and the date set for the order to show cause hearing. The court directed Mr. Flangas to appear and show cause. White shouldn't be held in contempt of court for failure to comply with the court's August 17, 2021 order and proceeding order where sanctions were levied against Mr. Flangas for his admitted and willful failure to comply with the discovery rules of the court. I have not heard from Mr. Flangas. He did file on September 16, 2021, a motion to extend the time to respond to the motion for order to show cause. So it's clear he was aware of the obligation to be here. Otherwise,
Was there a request to submit filed in connection with that ever?
I did not receive any request to submit, Your Honor, and I did not respond to the motion that was filed after we sent for service our request to submit the motion.
We had previewed the file to see if there were any requests to submit, and I did not see any. So do you have any idea what's happening with Mr. Flangas?
Mr. Flangas has been replaced as counsel, right? In Mr. Toll's case pending against Mr. Gilman. And it's my understanding he's also been replaced as counsel on the appellate matter. I did not receive any recent communications from Mr. Flangas' office about what's going on, and I'm unaware of why he continually fails to comply with court orders or even respond to motions that we file in the case, Your Honor. Like, given the circumstances, it's gotten to a point where the situation is extreme. I'm in my some 12 years of experience doing civil litigation. I've never encountered this before. Mr. Flangas admitted that he was at fault for the underlying problem, yet he fails for some unexplained reason to comply with the court's requirement that he compensate him for the time it took to bring that issue before the court, etc. So we believe that at this point, in order finding Mr. Flangas in contempt and other various remedies is appropriate.
What remedies do you think would be appropriate?
Initially, Your Honor, a finding of contempt, $500 fine as provided by NRS 22, I believe it's 010. Payment of the additional attorney's fees time incurred in further pursuing this matter subsequent to the court's August 17, 2021 order. Interest on any sanction or judgment until paid at statutory rate, and any other remedy that the court would find appropriate under local rule 1.12b. There's 14 essential different options the court has to deal with this type of situation, other than the statute, which frankly is quite antiquated, the contempt statute. We're not going to seek that the court go out and arrest Mr. Flangas to force his compliance, although it's perfectly within the court's authority to do that given his compliance with the court's orders. But we believe an additional remedy under Rule 1.12 may be appropriate given the circumstances and the apparent willfulness of the noncompliance. Frankly, it's pretty tragic when a member of the bar willfully refuses to play by the rules prescribed by the court, despite the issue repeatedly being brought to his attention. I'm not sure what's going on with Mr. Flangas. I hope it's not a serious personal matter that's causing this to happen to him, but I'm not aware of anything that would justify this type of conduct.
I did not review the motion for extension because there was no request to submit. Did he assert any health, personal issues in the motion?
Your Honor, no, I don't believe so. And I have a copy of the motion here. Attached to it was a declaration, basically, which states that he was at a charity event around the time of September 7th. He chaired the event, so he was out of the office. His staff attempted to contact me via phone and email. I did not respond, and I never addressed the issue of the extension. What did happen, I never received an email from them. I got a call. I've let Mr. Flangas know based on things that have happened in the past in this case that I wasn't going to communicate with him over the telephone, that I required everything to be in writing. We eventually exchanged text messages with his assistant, and I told her that I wouldn't agree to an extension. And I believe that was requested on the day the response was due to the motion.
I'm going to have you prepare a proposed order indicating that we held a hearing, that you and Mr. Toll were present, Mr. Flangas was not present. Mr. Flangas did not, apparently he did file an extension, but no request to submit, so the matter was never brought to the court's attention. So I am going to order that he pay all of the attorney's fees incurred by Mr. Toll directly related to this motion and hearing, that he pay interest on the sanctions that have been imposed at the legal rate from the date that the sanctions were imposed. I'm going to review the First Judicial District Court rules regarding sanctions. I may include others. I may be ethically obligated to make a complaint to the bar. I will review the Nevada Code of Judicial Conduct, and if I'm required to do so, I will do my duty there. I'm not going to impose a $500 fine. That sounds like a criminal penalty to me, and I think that this has been handled, let me say it a different way. It has not been handled in a criminal way, where I have a hearing, advise him of his rights, go through all of those things just like I did with Ms. Schultz. So in the order, just include at the bottom a little box for me to mark if I'm going to impose additional sanctions under the district court rule, and some lines that I can write on so that you can get the order to me and we'll have it done rather than delay.
Yes, Your Honor.
I do want you to send a copy of the proposed order to Mr. Flangas before you send it to me. You can give him a reasonable amount of time to review that. I want you to indicate when you transmit the order to the court that you have done that. You have sent the proposed order to him. You've given him a reasonable time to respond. And when I say reasonable time, you need to do a specific amount of time by a certain date, 7 days from the date of the communication, whatever, so that it reasonable is mushy, a date certain.
Your Honor, are you allowed to file a proposed order with the court, serve it according to the regular rules, and email it to his office as well?
If you did that, I'd give him 17 days, which is the time to respond to a motion. I understand this is not a motion, but there's not a rule for responding to a proposed order. So if you're satisfied with that, that's fine.
Yeah, 17 days is fine. What we'd like for him to do is comply with court's previous orders, and if that gives him a little bit more time to do that,
Understood.
that's with us.
Okay. Anything else?
Nothing further, Your Honor. Thank you.
All right, thank you. Court will be adjourned.